We do begin with breaking news. Same-sex marriage is once again legal in the state of Utah.
Yeah, that's because of the ruling coming down about an hour ago on Amendment 3 from the 10th Circuit Court of Appeals. Chief Political Correspondent Glenn Mills is here to break down the ruling for us. So, Glenn, what do we know so far? I mean, this just coming within the hour.
Major news. This is a historic case, not only for the state of Utah, but really for the entire country, you guys. 108 pages on this ruling. We have uncovered the basics to be able to let you know what that entails. And what I can start off, guys, we had a 2-to-1 decision here, which was expected. That's what a lot of people who watched the case play out in Denver were expecting, a 2-to-1 decision. That's exactly what we had. And the most important thing we should really get to off the top is this court, the 10th Circuit Court of Appeals, based on the Supreme Court staying the decision on them, they also felt it was necessary to issue a stay on their ruling too. So what that means is, unlike the situation we had on December 20th when Judge Robert Shelby ruled that Amendment 3 was unconstitutional, we saw that rush to for same-sex couples to go to county clerks and get married. We will not see that in this case because of that stay. And essentially what they're doing is giving the state time to respond to this ruling and decide what they are going to do.
Now let's go back to the reasoning, because you were there in Denver. You sat through these entire proceedings. You heard everything. So why the 2-to-1? Why not unanimous either direction?
Yeah, great question. And we really saw it play out in the 10th Circuit Court of Appeals in Denver as we were there. Judge Kelly was the dissenting voice in this decision. Lucero and Holmes voted in favor of it. And really that's what we saw on the questioning for the state and the plaintiffs all throughout. Kelly kept hitting on this issue of, look, there's no precedent for us to overturn what the voters of a state have voted into play, that of course being Amendment 3 back in 2004 with a 2/3 majority at that point. That's what he kept hitting on. Lucero and Holmes, on the other hand, they kept hitting on the 14th Amendment and the due process of same-sex couples. In fact, I'd like to read a little bit of the decision there because it's very important to the case. It's in the case quite a way, but he says in summary, these are the two in favor. We hold that under the due process and equal protection clauses of the United States Constitution, those who wish to marry a person of the same sex are entitled to exercise that same fundamental right as recognized for persons who wish to marry a person of the opposite sex. And again, you guys, that all centers around the 14th Amendment of the U.S. Constitution.
So we have a stay in this ruling right now.
Right.
So there won't be rushes to the county clerk. But what's next? I mean, is this certainly under the Supreme Court? That's what they've said all along.
The state, both sides really have said all along that they intend to take this to the very end. So we are anticipating the state to stick to that. It would take a major change of heart for them to decide, hey, we're not going to pursue this. But all indications are that the state will appeal this to the Supreme Court. And because of that, you guys, this could become the sweeping law all across the country.
I was wondering if, I mean, will this be the case, you think?
Yeah, very well. It very well could be. See, there was a window of up until July 1st that the 10th Circuit Court of Appeals had to unveil this ruling, which they have done in that window. And because of that, it now opens it up for the session to go to the Supreme Court. So it very well could be the deciding factor in same-sex marriage all across the country. And that would be quite interesting. You know, you talk about the big major cases of our time, Roe v. Wade, Brown v. Board of Education. We could have Kitchen v. Herbert as the synonymous cases for the same-sex marriage case.
We also have to talk about the other cases going on. We have all those marriages which are kind of in limbo right now that happened while gay marriage was legal in the state of Utah. They put a stay on that. Those marriages are not being honored by the state. What does this do to those cases?
Well, I talked to John Mejia. He's with the Utah ACLU, and he's representing plaintiffs in the recognition case. Those are plaintiffs who are demanding the state recognize their marriage, the marriage that took place within that 17-day window when it began on December 20th with Judge Robert Shelby's ruling. But we also have seen adoption cases play out in the state of Utah as well, same-sex couples wanting the state to recognize their adoptions. So again, talking to John Mejia from the ACLU, and he tells me that this is a very good indicator of his case, and he also says that his case will continue. This does not by any means mean that it is the end for his case, but definitely, you know, we're seeing for sure that federal judges are ruling on the side of same-sex marriage, and this, to my knowledge, is the first time that a court of appeals has ruled on that, so very significant in this case.
Glenn Mills, our chief political correspondent, joining us. Thank you. I know that was a lot of paperwork to get through in a short amount of time.
A lot more to get through.
And we should point out, you're going to be off the desk and going around in the field. You'll have reports for us 4, 5, and 6 tonight.
We have all the angles covered. I'm not the only reporter on this. We have several reporters on this. We're going to cover the state's angle. We're going to take a look at what this means legally, and we're also going to get a response from plaintiffs as well. So we've got this all covered, several reporters on the story.
We'll look forward to that.
Thank you very much, Glenn Mills.